Good morning, good afternoon, or good evening. Good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, the judge said, listen, Sean, Alex, all I ask for you to do is to be proper and organized and follow the procedures of the court. Let me drink my tea or my coffee. Let me settle down. And I shouldn't see your name across my desk 17,856 times. Now, thank you for my rendition of Judge Annalise Torres. Listen, housekeeping, please like this video. And if you like what you see, please subscribe. And once you subscribe, you'll be open to a plethora of new videos that I have completed. If you are a member, you will see that you have a lot of members only. You have first peek of some videos that I have done. So you have that first peek, and I'm going to keep honoring that you have the first peek, and then it'll go live to the public later. So that's my New Year's resolution to my members, and thank you so much. And if you'd like to join, memberships are available. Listen, y'all, you remember I reported a few days ago that Jay-Z attorney filed a motion with the judge to have to ask for a hearing to have this case dismissed. And he presented a letter to the judge, and we went over that in that video. Well, today, looks like the judge sat down, had her coffee, her tea, looked across her desk, and she didn't see 15,852 motions and letters from Jay-Z's attorney. So she was able to sit down and read that information. And so what we have today, I'm going to pull up that document. Give me just one moment. So here we go. So this is Annalise Torres, and it's an order. And it was filed January 2nd, 2025. The court has received defendant Sean Carter's letter seeking leave to file a motion to dismiss plaintiff's amended complaint and plaintiff's letter in opposition, ECF, numbers 55, 57 accordingly. Carter's request to file a motion to dismiss plaintiff's amended complaint is granted. By February 6, 2025, Carter shall file his motion. By February 28, 2025, plaintiff shall file her opposition papers. And by March 14, 2025, Carter shall file his reply, if any. The clerk of court is respectfully directed to terminate the motion at EFC number 55. So ordered. Well. See what happens when you do things proper and organized. So let's go over here. Because remember I told you that Alex Spiros had written the letter. I see, and shout out to Megan Cuniff, she had it on her X account. We have his letter. And so I am going to read that letter. Let me see. I need to share my screen. All right. So this is the letter that the Busby Law Firm had written in response to Alex Spiros' letter. So here we have, Your Honor, I write on behalf of Plaintiff Jane Doe in response to Defendant Sean Carter's letter dated December 30th, 2024. Docket number 56, pursuant to which defendant requests leave to file a motion pursuant to Federal Rule of Civil Procedure to dismiss plaintiff's First Amendment complaint. Defendant states his intention to move for dismissal on the grounds that Doe cannot pursue her claims under the New York City Victims of Gender-Motivated Violence Protection Act because the GMVA does not have retroactive effect. However, neither the Second Circuit nor New York Court of Appeals have endorsed this reading of the GMVA. In support of his argument, defendant cites a trial court order decided on an unopposed record, which is merely persuasive authority. Defendant's argument as to the GMVA is unpersuasive, as it is contrary to the law's primary intention to make it easier for victims of gender-motivated violence to seek civil remedies in court, not, as a defendant would have it, make it harder. New York City passed the GMVA in light of the void left by the Supreme Court's decision. The Supreme Court, however, urged local governments to provide a remedy to women like Morrison who had been brutally essayed, as no civilized system of justice could fail to provide her a remedy. GMVA shows the council intended to fill the void left by Morrison. The city council recognized that gender-motivated violence is widespread throughout the United States, and that 3 out of 4 women will be the victim of a violent crime sometimes during their lives. The council also concluded that victims of gender-motivated violence frequently face a climate of condensation, indifference, and hostility in the court system. The council sought, therefore, to create a private right of action for victims of gender-motivated violence to resolve the difficulty that victims face in seeking court remedies by providing an officially sanctioned and legitimate cause of action for seeking redress for injuries resulting from gender-motivated violence. The council intended the GMVA to make it easier for victims of GMV to seek court remedies, and intended the same when it passed the 2022 amendment to the law. Similarly, defendant also intends to seek dismissal on the grounds that any viable GMV law claim is time barred under the New York Child Victims Act, which preempts plaintiff GMV law claim. However, this court found that local anti-discrimination laws are generally not preempted by state law in New York. Finally, defendant intends to seek dismissal on the grounds that the conduct alleged in the FAC could not have occurred in New York City based on plaintiff's description of the residence in question, combined with public records, confirms that any such residence was located outside of New York. As defendant seeks to rely on evidence outside of the pleadings, which would transform a motion to dismiss to one for summary judgment, and as discovery is not yet underway, it is respectfully submitted that defendant's proposed motion is procedurally improper and should be denied. In light of the foregoing, plaintiff respectfully requests the court to deny defendant's request for file of motion. This is, I will tell you what, this is going back and forth, back and forth, back and forth, back and forth. But I wanted to come and keep y'all abreast. Jay-Z say he want to get out of this. And he's sick of y'all. Jane Doe says, not so fast, not so fast. We have not done discovery. So therefore, i.e., there will be no judgment for you. Anyway, what are you all thinking about this? I'm just going to keep y'all abreast of everything. I don't know what to tell you. It's just going back and forth and back and forth. I don't know. Well, I won't say that. I won't say that. Y'all, if y'all like what you see, please hit that like button and also subscribe. Listen, please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people, bye-bye. Child, this is going to go back and forth, back and forth, back and forth. And I'm here for it. Let's see what the judge says. So again, by February 6th, Sean Carter should file his motion. By February 28th, plaintiff should file her opposition papers. And then by March 14th, Carter should file his reply. So they're on the docket.